Aboard, your learning journey starts now. Ever wonder how a courtroom drama over a patent actually works? It's not just about who's right, it's about layers of meaning, hidden agendas, and the constant push and pull between facts and feelings. We're diving into the secret sauce, the DIKWP model. So, who's playing this high stakes game? You've got the plaintiff, the defendant, the judge, maybe even an expert consultant. Think of each one as a mini universe with their own DIKWP layers. The plaintiff has got their raw data, technical specs, sales numbers. They process it into info, comparing features, building claims. Then comes knowledge, citing laws, arguing against prior art. Wisdom kicks in with strategy. Should they settle or fight? And the ultimate purpose? To keep their monopoly tight. The defendant plays the same game, but their goal is freedom, avoiding the patent trap. The court. They collect everyone's data, weigh the knowledge, apply wisdom, and aim for justice. See the potential clashes already. Data says yes infringement, data says no. Knowledge argues different legal interpretations. Purpose screams monopoly versus market access. It's a semantic battlefield. Now, how do we measure this intellectual sparring? Enter the magic formulas. We call the heat of conflict semantic tension. Imagine a tension meter, T of I, J, T. It measures how much two things disagree, say, the plaintiff's evidence versus the defendant's defense, or the judge's interpretation versus the law. A value near 0 means harmony, near 1 means total showdown. Then there's the propagation weight, W of D to I to K. This tells us how strongly an idea travels from one layer to another, or from one player to another. If the plaintiff's evidence is weak, that weight drops, and their argument loses power when it reaches the judge. It's like a signal getting weaker or distorted. This model helps us spot broken chains, where the logic doesn't hold up, and see if a closed loop of reasoning forms, leading to a resolution. It's surprisingly neat math for messy human drama. Let's zoom out. What about the patent itself? That document isn't just paper. It's packed with DIKWP layers, raw tech data at the bottom, cleverly structured into claims and descriptions linked to existing knowledge, reflecting the inventor's strategic wisdom and ultimately pointing towards their grand purpose. Market control. Now, when the court makes a decision, it's not just an end. It sends ripples outwards. The judgment becomes new knowledge for future cases, shaping the case law database. More importantly, it directly impacts the industry's semantic landscape. If the court sides with the patent holder, suddenly everyone else feels the pressure, competition shifts, cooperation might change. If the patent is deemed weak, the field opens up, encouraging innovation, but maybe also making innovators nervous about returns. The court's ruling acts like a powerful semantic force, reshaping the entire game board. Does this fancy model actually work in the real world? Let's look at a real patent fight over an energy-saving algorithm. Using our DIKWP glasses, we clearly saw the knowledge layer clash. Is it really equivalent? Is it truly novel? And the massive purpose layer showdown, monopoly, or market access. The court used its wisdom to navigate this, eventually ruling infringement but giving a grace period. That grace period? That's the court actively managing the tension, showing some empathy for the defendant's business reality, even while protecting the plaintiff's rights. We can even use this model to find similar past cases. Compare the semantic fingerprints, the key issues, the layers of conflict, and bam! We can explain why a similar case might have a different outcome, based on the specific evidence and value judgments involved. It's like having a superpowered detective tool for legal mysteries.